Good morning, and thank you for joining me on the Path to Liberty. It's Monday, January 17th, 2022, and I think by now you've probably heard plenty of hot takes on those Supreme Court opinions that came down last week on the mandates, and there certainly was some good news, so let's not ignore that. But I want to stress that it's just some good news. So on this episode, I figured you might be interested in my own cynical take on everything from Sotomayor to the OSHA Act of 1970 and what those opinions leave the door open for in the future, how to deal with it, and the like. I wrote a blog about this last week and sent out an email campaign. So if you've been reading along with all the stuff that we're doing, you're probably up to speed, and maybe I'll have some off-the-cuff additions to all that. But for those of you who just watch or listen to the show, this might be the first that you've heard these takes. But first of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific Time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage is everything you need to follow us. It's 10thamendmentcenter.com/path to liberty. It's all spelled out. There you're going to find all the archives for the show. You're going to find all the different platforms we're on. We're on a bunch of video platforms. We're on a bunch of audio-only podcast platforms. My favorite on the video end is Odyssey.com, which is decentralized and censorship-resistant. It's far from perfect, but it certainly is moving in the direction away from centralized control. I see a lot of people, and I was tweeting about this over the weekend, a lot of people have been complaining to me about Getter being bad. And we have an account or a profile on Getter as well. We post there maybe 1 or 2 times a day. And the complaint is about who's funding it or terms of service and stuff like that. But rarely is it about the fact that it, just like almost all the others, it is a centralized platform. And when you have a centralized platform, that means it's up to the platform to make the decisions on who's going to be there and who's not. And that's the problem that we have with the big mainstream platforms. It's also a single point of failure where the government can pressure the platform to do what it wants. So decentralized, censorship-resistant, for a side introduction convo on social media over at Odyssey.com. Over on that show homepage, I actually publish an individual blog post for each individual episode, and that's where I link to stuff that I reference because I'm just scratching the surface, and that way you can find all the stuff that I'm talking about and read and learn more in context on your own time. I generally publish that anywhere from 1 to 2 hours after the live broadcast is done. And you can also find our membership program where you can put your financial faith behind our work. There is nothing that helps us more than the financial support of our members. If you're able to pitch in, I do urge you to do so today over at 10thamendmentcenter.com/members. And again, the show homepage, 10thamendmentcenter.com/path to liberty. Enough with the ads. Let's give everyone another quick moment or two to get notifications on those mainstream platforms and join us on the live stream. But in the meantime, I want to say hi to everyone out there. There's Tim in Arizona, Haji in Michigan, Oakland County, Dixie Strong in Alabama, Andrew Green, good to see you in Northwest Missouri, Cheriton Farmer also in Missouri, John Hume in Pennsylvania, happy MLK Day. One has a moral duty to disobey unjust laws. I cannot do MLK Day justice, but that is my favorite quote. Clay Kent, Thomas Staples in Central New York, Erwin Havranek in Omaha, good to see you. Israel, Murray Ray, Gene Holtzclaw, Joe, Lawrence Smith, Pop Basketball, Ed, and everybody else. I really appreciate you spending some time with me today, and I hope maybe you're having an extra day off or you had a great weekend, but let's get right to this. And I'm pretty confident that by now, most of you are aware that last week, I guess it was Thursday, the 13th, the Supreme Court issued 2 pretty big opinions on mandates. I want to let's see if I can get this pulled up on the screen here. I wrote a blog post about it just maybe an hour or so after it came out. The good, the bad, and the ugly on the Supreme Court vaccine mandate opinion. It should have been pluralized. And here's how I started. There was one, this was a 6-3 opinion against the employer mandate. That's positive. In the other, Chief Justice Roberts and Justice Kavanaugh joined the so-called liberal. I hate generally calling them liberal and conservative, but this made it clear, I think, in the lead of the post. Joined the liberal justices to form the majority. It was 5-4 in upholding the mandate for Medicare and Medicaid service providers. So half and half, or is it even half and half? Let's look into this. Now, I would certainly make the case, just like I'm starting out here, it is absolutely positive that somewhere between 80 and 100 million people are not going to be forced by the federal government to be in a position of trying to get their employer to either violate what the feds want them to do or do it themselves or lose a job. So that is a positive outcome in some degree, at least for the short term. I don't think it's going to last forever like that. And I don't think they're just going to throw in the towel after this and be like, well, we lost and there's no other way to do this. We have to pay attention to what has been left open. So the fact that the Supreme Court got part of it right, at least on the legality of some technicalities under the ETS, the emergency authorization of the OSHA Act, that's partly good news, at least in the immediate term for people's day-to-day lives, even if it's very narrowly. But it isn't time to be jumping for joy in the streets. Let's put it that way. And I think as a quick aside, this is as good a time as any to remind you that the Supreme Court issues opinions. It doesn't make law. There is no legislating from the bench. And when the Supreme Court does the right thing, it is their opinion. And we can agree with that opinion or not. And when they do the wrong thing, it is their opinion. We can agree with that opinion or not. And here's the two cases. And these are slip opinions, so they've been published at supremecourt.gov, but they're not the final documents, but they're at least there. Here, first of all, NFIB versus OSHA. That was the employer mandate. You can see it right at the top. This opinion is subject to formal revision. This is an opinion of the Supreme Court. When you're at supremecourt.gov, there's a link at the top for opinions. The other case, the 5-4 on Medicare and Medicaid, this is Joe. We'll say Joe versus Missouri. And again, this opinion, these are all opinions. Now here, for example, we even have Chief Justice John Marshall, who I've been citing a little bit more lately on some healthcare laws. And I know most people who support the original legal meaning of the Constitution look at him as an enemy, and I can understand why. But if even Marshall takes this opinion, then I think it says quite a bit about what we're living under today. Here's John Marshall. Courts are the mere instruments of the law and can will nothing. And again, this was from his 1824 opinion in Osborne versus Bank of the United States. He says, judicial power is never exercised for the purpose of giving effect to the will of the judge. It's not just supposed to be the opinion, the political choices of the judges. And in fact, on almost every major situation, we find a lot of it is really just based. That's why I think it was a good idea to include the liberal judges, because, and the conservative judges aren't as all that conservative. They're not constitutionalists. So it's liberal versus constitutional political views. And a lot of times those opinions, those decisions, those rulings, as a lot of people call them, are really clouded in political goals. For example, and I know I mentioned this in an episode last week, the Gonzalez versus Raich case, I miscited the year of 1995 like 3 times. Sorry, it was 2005. This was the famous California medical marijuana case where Justice Scalia wrote the opinion for the majority that held that growing a plant in your backyard, consuming it at home, never buying or selling any of it, the seeds, nothing, was somehow interstate commerce. He upheld the precedent, the unconstitutional precedent from the FDR era, from Wickard versus Filburn, one of the worst ever. Because, of course, conservatives did not want California defying the feds on their unconstitutional prohibition. So this is an example of judges giving their own will rather than putting the supremacy of the Constitution above it all. Here's even Marshall. Judicial power is never exercised for the purpose of giving effect to the will of the judge. I wish he would have held to his own viewpoints there, but always for the purpose of giving effect to the will of the legislature, or in the words, to the will of the law. It really should be the will of the people of the several states who gave legal force to the Constitution. So even there, it's a bit of an error, but I hope that comes clear. I just wanted to add that to the convo. So here's the good. It's good news. It's narrow. It's probably short term. But the Supreme Court held that the mandate for businesses is illegal. And I wrote this: we gotta take a win where we can get it. And that's really the end of the good news, because we know that they upheld. Once again, I think it's like 75% of the time when they get these cases, there's been some studies on this recently, the Supreme Court upholds federal power a vast majority of time all through history. And I do think that this good news is only temporary. So it's important to understand that this Supreme Court opinion wasn't based on the constitutionality of OSHA. It wasn't based on the constitutionality of the mandates. It wasn't based on the constitutionality of anything under the Commerce Clause or whether or not the OSH Act of 1970 should even exist. Of course, I would argue that it wouldn't, but it's important to understand that the opinion on the business mandate is largely based on the argument that Congress didn't expressly authorize a mandate in that OSH Act of 1970. So the big reason that they went 6-3 against it was basically, well, Congress didn't specifically tell OSHA that they could do this back in 1970. And I know you're smart enough to understand that that really means that they would very seriously consider it okay if Congress were to just do that. And although I think it's very unlikely in the next few months, or maybe this year, to see Congress pull that off, I wouldn't be surprised if it happens this year or next year or in 5 years or 10 years or 50 years or 500 years. It doesn't matter when. As Thomas Jefferson told us in 1791 in his opinion against the constitutionality of the First National Bank, that was Alexander Hamilton's brainchild, he said to take a single step beyond the limits of the Constitution is to take a boundless field of power, because soon as you can allow them to break that line, what else can they do? They'll never stop. The founding generation, other than Hamilton, or maybe Hamilton knew this as well and he wanted to use it to his advantage to centralize more power, but they understood that precedent was the problem. As soon as you give them the precedent to do something they're not supposed to, something else will come along. And that's my argument about the OSH Act of 1970. People have turned a blind eye to the notion that the federal government could, that act in and of itself was authorized by the Constitution. And sooner or later, here it is decades later, they're doing really crazy things or trying to do really, really crazy things. Anyway, so they were basing this on the argument that Congress just didn't include that in the original act in 1970. And that I think is very problematic. And I know it's kind of it's a narrow case for those of you kind of legal watchers, and they weren't really going to address that constitutionality, but that really is what the problem is underneath it all. And here's from I guess it was an unsigned opinion, at least, I'm not sure. Here's how they put it. Again, back to, this is NFIB versus OSHA, and this is from supremecourt.gov. I will link to it in the show notes so you can read it yourself. Although Congress has indisputably given OSHA the power to regulate occupational dangers, it has not given that agency the power to regulate public health more broadly. So the argument was really, okay, Joe is telling us that this is to advance a public health issue. And the statute or the act that they passed in 1970 was really about workplace safety. So now if the court is basically telling us that if they had added some national health things in there as well, in essence, they could have pulled it off. It just needs to be amended a little bit. Requiring the vaccination of 84 million Americans, they write, selected simply because they work for employers with more than 100 employees, certainly falls in the latter category. And they're just saying Congress didn't do that in the original act. I agree. They did not do that in the original act. And I think the entirety of the Supreme Court based on this, there is no dispute on the Supreme Court over the constitutionality of the OSH Act, which created OSHA back in 1970. I think it's unconstitutional since day one. I think the TAC has done a bad job. We have not pointed this out over and over. There's so many agencies. And this happens from time to time. All of a sudden, it's like, wow, we should have been talking about this all along. We should have been talking about all these unconstitutional agencies all along and warning, well, they might do something. Unfortunately, we don't have enough resources and person power to pull that off, but you might join as a member today and help us reach more people and maybe hire someone else to join the team, 10thamendmentcenter.com/members. But anyway, so there's really no dispute. It's indisputably they've given OSHA this power, is what the Supreme Court is telling us. There's no dispute over this. And on top of it, they're basically leaving the door wide open for Congress to do whatever the hell they want moving forward. That's what it sounds like to me. Just add to that the OSH Act. Just add that stuff to the OSH Act, and Congress and the Supreme Court, they're all going to be okay with it. That's what it sounds like to me. And I know there's been a lot of people ripping on Justice Sotomayor, and for good reason. But I don't think people are grasping the gravity of what she's actually doing here. I don't think she's as dumb as we would like her to be. I think she is sly as a fox. What's the phrase? Here's Kevin Gutzman, great friend of the TAC for many, many years. He cited her as he was listening to those oral arguments. This is from a tweet he posted. I will link to that as well. Quote, I'm not sure I understand the distinction why the states would have the power, but the federal government wouldn't. Of course, if you look through replies or comments on these types of posts, and we found them all over, the answer is the 10th Amendment. Of course, the federal government doesn't have what's called a police power. James Madison in Federalist 45 told us that the powers delegated by the proposed Constitution to the federal government were few and defined. They were enumerated in the document. Those reserved to the states, the people of each state, were numerous and indefinite. Numerous and indefinite power is basically what's known in law as the police power. The federal government does not have general legislative authority. I covered that last week in an episode talking about health care in the Constitution. I also covered that last November in an episode talking about the General Welfare Clause and introduction. I'm just thinking of this stuff off the top of my head as I'm talking about it. So a lot of people are laughing about that, but I just don't think people are fully appreciating the context and what she's really trying to pull off. And I think rather than just laugh about it, we should be very concerned. And let me pull up the rest of the comment in context. She says, you seem to be saying that the states can do it, but you're saying the federal government can't. Even though it's facing the same crisis in interstate commerce that states are facing within their own borders. Think about that. She's specifically referencing interstate commerce. So this isn't a confusion by Sotomayor about what's supposed to be delegated to the federal government and what's supposed to be reserved to the states. This is actually an affirmation. This is an affirmation and possibly an attempt to expand through her own comments a little bit current Supreme Court precedent, which has been around for a long time, that says that the power that the federal government has under the Commerce Clause is not just about merchants trading with people, doing actual commerce across state line, but it's also what Justice Scalia was against in 2005 in that Gonzalez versus Raich case, and what FDR absolutely hated back in the Wickard versus Filburn case. That is, people doing activity totally in their own state, never, ever, ever having that economic activity leave the state or even be non-economic activity. And that is somehow under the purview of the federal government to regulate, control, mandate, and prohibit under the interstate commerce power. So she's talking about like, well, of course, we can do basically whatever we want as long as the activity merely have some kind of effect on interstate commerce. And the argument that Scalia actually pushed forward, that he continued, that was, I think, a 5-4 opinion. So if he actually just stood with the Constitution, things might be far different today. But unfortunately, we can't rely on any of these judges because they're politically motivated. And a cannabis case for conservatives in mid-2000 was certainly a political issue, even though there were some states that were actually filing briefs on behalf of California. I think Louisiana, Mississippi, Alabama were saying, like, basically, like, if you tell California that they have to change their law based on this, what are you going to tell us? And that is a very serious warning. Justice Thomas was really good on that one as well. And he basically took the position that, well, if the Supreme Court can regulate 6 plants grown in someone's backyard, their power under the Commerce Clause is limitless. And that is exactly what Sotomayor is getting at here. She's saying, well, of course we have this type of power. Why is it up to the states if we have this unlimited power of anything that touches any type of commerce? As soon as you have a job, that affects interstate commerce in some way. Someone can make the argument that this somehow touches that. It's like the 6 degrees of Kevin Bacon, but it's the 6 degrees of interstate commerce. The idea that literally growing something in your backyard that's illegal to even have in interstate commerce is somehow affecting interstate commerce and allows the federal government to control, regulate, prohibit, whatever, says quite a bit. So check out this exchange between Benjamin Flowers, I think of Ohio, and Sotomayor on that same day. She says it does have power with respect to protecting the health and safety of workers. So they're saying, oh, the federal government has total unlimited power over health and safety. She says, we have accepted the constitutionality of OSHA. No one's disputing the existence of OSHA on the Supreme Court. Flower says, yes, I took you to be asking if they had a police power to protect public health. And I don't think she was actually being dumb here about what police power is. I think she was actually inserting that intentionally because she wanted to make the case and have her side of the coin start taking the position in the public sphere that there is an unlimited police power under the Interstate Commerce Clause, under Article 1, Section 8, Clause 3, which in essence they're very close to. It's not going to take too much longer before it is virtually unlimited. So she says, no, they have a police power to protect workers. So under the OSHA Act, OSHA is totally undisputed constitutional according to the federal government, according to the Supreme Court. There's no one in Congress trying to get rid of it. You never hear about a presidential candidate talking about getting rid of it. So this is totally bedrock, not going anywhere based on what the feds want to do at any level. You can't rely on them. So she says they basically have this police power, unlimited power to protect workers. Flower says, I would not call it a police power. So he's being, I think he might be getting dragged into a debate over something that is a little different. I would not call it a police power. I think the commerce power, so even the opposition now joins in. I think the commerce power allows them to address health in the context of the workplace. So the opposition is saying, okay, well, they don't have an unlimited police power. Madison told us that was reserved to the people of the several states in Federalist 45. They don't have that, but the commerce power gives them basically unlimited power to address health in the context of the workplace. Sotomayor says exactly. So she's really saying two things here, and I just can't stop hammering this home. The feds have an unlimited power to protect workers under OSHA, and I don't think there really is much disagreement about that. It's just whether or not Congress has made the decision to include these types of mandates in the OSHA Act. And they have vast power under the Commerce Clause to address in the workplace and pretty much anywhere. There's actually very little disagreement on this on the federal court between the so-called liberals and the conservatives. Now, I mentioned a couple of episodes. In recent episodes, one is 4 cases that expanded the Commerce Clause. There's 3 cases from the New Deal era and that 2005 case, which I kept citing wrong as 1995. 2005 case, Gonzalez versus Raich. These are very important in understanding how the federal government views its power under Article 1, Section 8, Clause 3, the so-called Interstate Commerce Clause. And then this other one, I think is even more important because we're talking about this indisputable power to protect the health of workers, or this idea that, well, Congress didn't just add protecting health to the OSHA Act, so they just got to go do that. Kick it back to the political branch, to the legislature, and, well, the political branch. That was a mistake. They're all political branches. Let's not forget that. They're all bad. They're all political. They are not following their oath to the Constitution. Not even close. I'm sorry for that mistake. Hopefully that wasn't too bad. But kick it back to the legislature. Okay, we'll just add this to the act, and then we'll look at it later. Maybe you'll go too far, maybe you won't, but you know what our precedent is all about. So if you keep it within that, you're probably good. And we'll always expand on that precedent over time anyways. So I covered the idea that the Constitution does not authorize any health laws of any description to the federal government. I made that case under original viewpoints. That I did an episode on last week. I will link to that in the show notes. Please do check it out. And here again, I cited John Marshall. If John Marshall is telling us health laws of every description, not just some or some regulations or certain very specific things, health laws of every description were outside the purview of the federal government and are matters for determination by the states. That was in Gibbons versus Ogden of 1824. If even Chief Justice John Marshall said that, and no one on the Supreme Court today is saying that, that tells us we have a much larger problem than just getting the right people in office to pick more of these horrible, horrible justices. And that brings me to my main problem with that first opinion, NFIB versus OSHA, not on the technical approach or anything that. And while I'm glad there isn't going to be a mandate to really screw with the lives of 80 to 100 million people, 84 million, whatever the number is. If it was 10, it would be wrong. Even though that is a positive. All we're really getting is that from SCOTUS. That's it. That's it. A temporary pause on the expansion of government. And it isn't even a pause because they expanded in the other case. So it's like you get a little slowdown here while you get a little more growth here. And at the end of the day, government always has more centralized power and control. Something that Patrick Henry warned about, consolidation, he said, would absolutely end in the destruction of our liberty. So that unconstitutional act of 1970, the OSHA Act of 1970, they're telling us, well, that unconstitutional act of 1970, that shouldn't exist. Well, it didn't specifically authorize that unconstitutional agency that shouldn't exist to do more unconstitutional restrictions or mandates today, and they should never exist, but they probably can as long as Congress tells us that that's what they want. That's really what I see that the Supreme Court opinion in NFIB versus OSHA is telling us. 6-3, go ahead and do it later. And that, my friends, is not the description of a free people. A free people, Thomas Jefferson told us, claim their rights as derived from the laws of nature and not as a gift of their chief magistrate. What we're seeing right now is a population totally on its knees, begging for scraps and seeing what their rulers and their rulers' courts, who are really the rulers at the end of the day, allow them to do. And I think it's the same situation in that other case, Joe versus Missouri. I like just saying Joe. It makes it a little bit more fun. I don't have respect for these people, so I don't want to treat them with respect. And it's not just one team, and I know a lot of people just want to disrespect one team or the other, but they're all evil. They're all part of the largest government in the history of the world. Constant violations of your rights. Whether you want to exercise those rights or not, they are absolutely violating them constantly. So if health laws of every description, as John Marshall told us, are reserved to the states, and many of the other founders and leading advocates for the Constitution during ratification told us, like, this is not in the purview of federal power. So the big government people were telling us this wasn't in the purview of federal power, yet they're still doing it today. That's why I say the problem is much, much worse than a lot of people want to admit. So if health laws of every description, not most or some description, all description, are reserved to the people of the several states, whether they want to have laws about them or not on each state, that's up to them, then Medicare and Medicaid, even if it's a partnership with the states, they shouldn't exist either. So it's not really about the feds being able to make different rules for federal employees in this 5-4 opinion. It's about them expanding rules for federal programs that shouldn't have existed in the first place. And at the end of the day, let me just see if I can pull up this screen here without screwing up what I'm doing here. This is how I summed it up in my blog post last week. I threw this together pretty quickly, so hopefully I did a pretty good job on it. Whether Congress gets around to expanding their own power this year or in 50 years, we shouldn't be surprised about it unless or until the people reject the foundation of it all. And that includes no longer waiting for the federal government to limit its own power. It's up to the people to preserve their own constitution. And I keep citing John Dickinson in his Fabius letter number 4 of April 1788. He put it this way, talking about the supreme sovereignty of the people having final authority, which is sovereignty. It is their duty to watch and their right to take care that the Constitution be preserved, or in the Roman phrase on perilous occasions, to provide that the republic receive no damage. It is the people's duty to make sure, not the people's duty to sit idly by and waiting with bated breath in the hope that the federal courts, which are part of the federal government, will say that the federal government shouldn't be doing what the federal government has been doing all along. That is not what a free people does. And now, mind you, that does not mean that I'm against the good news. The good news is that 84 million people are not going to have their lives interrupted immediately today. I mean, maybe not all of them, but some of them. And of course, the states are serious problems as well. So I know some people are just saying, oh, okay, we don't care about that other opinion. It doesn't affect us. All I care about is this one thing. And that's all we have to do. And that's really what we saw happen with the Affordable Care Act as well. When one part of it gets thrown out, the rest of it's still there. And that's still a huge problem. And that reminds me of Samuel Adams in his great letter of October 1771, his great essay in the Boston Gazette. And he said, instead of sitting down satisfied with the efforts we have already made, which is the wish of our enemies, The necessity of the times more than ever calls for our utmost circumspection, deliberation, fortitude, and perseverance. We need a lot of that. We cannot just look at these Supreme Court opinions and be like, well, that was a pretty good one. We got a win there. We're good. No, they may come back and push for, they absolutely will come back at some point and push to do more and more of this in the future. And every time they leave an opening, every time it's hinted that Congress should actually do something like this, or it's just up to Congress to spell it out, you shouldn't be surprised when they actually spell it out. Oh, how did that happen? I had no idea. I thought the Patriot Act was just going to be for the terrorists. Fear, fear, fear. You got a government and an ignorant, weak population that's sitting around living in fear of death at every turn, whether it's from a virus or from a terrorist or from crime or for whatever it may be, instead of being strong and supporting the natural right to keep and bear arms and self-defense as the primary law of nature. And then, of course, just like John Adams warned us in 1776 that fear is the foundation of most governments. I just like to remove the word most because fear is really the foundation of their power. I just want to take a quick look over in the live chat and see if there's any questions that I can answer briefly. White Space Marines says, what do you suggest we all do? I have probably 50 episodes on what needs to be done. That is not something I can answer very quickly, but if you want a starting point to learn what needs to be done, we do an annual report called the State of the Nullification Movement Report. It's about 140 pages. It's a free download. You don't have to leave your name, email, nothing. There's just links. Just download the thing. It's a free ebook that you can read, that the first maybe 60, 70 pages of it talk about the strategy that needs to be used, the constitutional basis from the American Revolution, the founding principles on how to deal with a federal government, with a government that doesn't follow its rules. And then the second half of it, or the second maybe 2/3, talks about how this is being put into practice on various major issues today. I do encourage you to read that in full because it will answer, it's 148 pages. That will answer your question quite a bit. And then dig through some of the other videos here. We've got a lot of things on how things are supposed to be done. One example is a video, if you want a title, Spooner's Strategy to Stop Usurpation, I believe. Spooner's Strategy on Usurpation. If you do a search for that, you'll find it on our website or whatever platform we're on. It basically talks about Lysander Spooner's arguments in the 1850s that were basically reiterating the founding generation's approach to how the people are supposed to deal with a government that doesn't follow the rules without waiting on the government to magically limit itself. Sharon Patriot says, reject the false premises. And of course, the false premise is that it's up to the Supreme Court. We got to sit around and wait for the federal government to limit its own power. Absolutely. White Space Marines, thank you. I really appreciate that question because it's a big one. And it's like we can talk about how there's so many problems, and I don't want to be that dude that just tells you all this stuff is bad without any solutions. We do a ton of work about solutions. In fact, that's most of it. Gustavo says, nice t-shirt. this is the second time I've worn it. This is one of my favorite quotes. Mercy Otis Warren, the muse of the American Revolution, she was talking about the right, a primary law of nature is the right of self-defense. And you're defending yourself when you're resisting the first approaches of tyranny. It's not available on our store yet. Maybe in the next week or so. I've been so underwater trying to push forward with some work during this nullification season, the beginning of the legislative session in the states. But we'll probably get this listed in our store pretty soon. I'll mention it. I'll wear it on a show and mention it again in the near future. We'll probably also add it if you're on YouTube. I'm not sure what platform you are on, but we also list those there as well. I need to order that in bulk. Absolutely. It's an important message. It's a very important message, and that's part of what we're talking about. How do we deal with this? We don't just sit idly by. You can't sit idly by. Because if you turn a blind eye to a violation of the Constitution, even if it doesn't affect you personally, what you're doing it, as Samuel Adams put it, is you're encouraging it and you're involving others in our doom. Anyways, I will look a little bit more in the comments a little bit later today. Please continue leaving those comments. I really appreciate your feedback. I get tons of ideas for future episodes in the comment section, probably more than any. Leave those in the archive, whether it's YouTube or Facebook, or you can also email me, team@10thamendmentcenter.com. Please don't forget, Andrew Green, obsta principiis, which means nip the shoot of arbitrary power in the bud. James Otis talked about this in the 1760s. So did John Adams. That's the only maxim, Adams said, that will ever preserve the liberty of a people. You have to nip the shoots of arbitrary power in the bud, and arbitrary power is any power that's not authorized to them. So great point, Andrew Green. Really appreciate that. Northwest Missouri, I think, right? Missouri is always representing strong here on this show. I really am grateful for that. Anyways, 10thamendmentcenter.com/members is where you can throw us a couple of bucks a month, and it really, really helps us a lot. We make it go a long way in support of the Constitution and liberty. And of course, 10thamendmentcenter.com/path to liberty. Smash the like button, reviews on Apple Podcasts, all that stuff, comments. That will help tell those platforms to trigger the algorithm and show the program to more people. Again, I hope you enjoyed this episode. I hope you learned something. It's not really great news, but I wanted to give it to you straight as I could think, and we've got a lot of work to do. So I'm glad you're here with me. I'm glad you're on board with defending the Constitution and liberty at its time of greatest danger. Thanks for being here, and I'll see you on Wednesday on the path to liberty.